And I'm Ron Meyer in Tallahassee on behalf of all plaintiffs.
Kimberly Mitchell, General Counsel for the Florida Education Association on behalf of the plaintiff.
Good afternoon to you, ma'am. Anybody else appearing on behalf of the plaintiffs?
Good morning, Your Honor. Lucia Piva with Phillips, Richard, and Wren, also on behalf of the plaintiffs.
Good afternoon to you. Anybody else wish to appear on behalf of the plaintiffs today? Okay, and anybody appearing today on behalf of various defendants?
Yes, good afternoon, Judge. Angel Cortinez from Gunster and my partner, Jonathan Caskell, also from Gunster, on behalf of the governor of the state of Florida, Ron DeSantis, on behalf of the Florida Commissioner of Education, the Florida Department of Education, and the Florida Board of Education.
Mr. Cortinez, we're getting a little bit of feedback from your presentation. Do you have like more than one device open there?
I don't, but let me turn off my phone just to make sure that that's not interfering.
Thank you.
Maybe that will help.
Anybody else appearing on behalf of the state defendants? And on behalf of Miami-Dade County?
Dave Murray, Lauren Morris, and Angela Benjamin, County Attorney's Office, on behalf of the Mayor, Carlos Metz.
Good afternoon to you. So we set this up as a scheduling conference today. Have this large group of attorneys had an opportunity to confer on scheduling in advance of the hearing today?
We have, Your Honor.
Okay, fine. Let me also start with a statement that I have a high school student in the Miami-Dade County Public Schools. Go High Tides. Okay, Mr. Coffey, do you want to take the lead today and tell us at least your point of view on the situation?
Yeah, Your Honor. The circumstances that have brought us here to get today are dramatic, tragic, and well known to all of us. With each pleading we file, it becomes necessary, or at least appropriate, a week or so later to report even more horrifying statistics. And now there are 500,000 COVID cases in Florida, 125,000 in Miami-Dade County, and tragically 7,600 people have died in the state of Florida. So we all know that this is very, very serious. And of course, these numbers vastly exceed the level of danger at the time months ago when the Miami-Dade and other schools around the state closed for brick and mortar and went to virtual learning. So we believe that human safety is the ultimate imperative. But our lawsuit takes specific aim at an emergency order that was issued by the Commissioner of Education, which we believe was issued in violation of the Florida Constitution in several critical respects. First of all, it does not sufficiently take account of the safety that is the constitutional right of every student in Florida. And while there are certain elements of a public education, such as quality, that are not judicially manageable. We're not here asking Your Honor whether a particular class in English or art is conducted appropriately. The element of human safety is indeed something that judges are able to deal with. And in fact, a case that's cited by the state defendants, Citizens for Strong Schools, the trial court, the issue didn't come before the appeals court, but the trial court emphasized that the terms in Article 9 relating to safe and secure are judicially manageable standards, and in fact said that Florida courts deal with issues related to safety and security all day, what's unreasonably dangerous, what's sufficiently safe. So that is an important part of our argument with respect to Article 9. With respect to the other count, which is arbitrary and capricious, we think that the order is confusing. It's not reasonably anchored upon data and evidence, and is subject to attack as essentially a violation of due process. The third count seeks recovery for injunctions. So that's the case that's come before Your Honor. Obviously, there had been a very positive development in Miami-Dade County itself, a development which, in pushing back the time for bricks and mortar learning, we believe has literally saved lives. But that is a reprieve. It is a 2-month reprieve, and it is certainly not a long-term safety solution. And as to the rest of the state, this is a statewide injunction that is being sought in the sense that it attacks an order issued by a state authority. We're not purporting to represent everybody in the state, but we have parties with standing coming before you who say that this state emergency order is unconstitutional. So it would indeed have statewide ramifications, and that process that we've come before you today on has continuing urgency around the state. In Miami-Dade, it may not presently be the center of greatest immediacy, but ultimately it is the center of the greatest potential harm. And for that reason, there is a pending venue challenge that will, I believe, prompt Your Honor to consider the issues of Miami-Dade in some depth. The parties came together on a status conference before Judge Arzola, who
I want to move to the scheduling in a moment, but and I don't know how much we're going to touch on the merits of the case, but since you made a statement as to your point of view, why don't we let Mr. Cortinius, or one of the attorneys for the state, make a brief statement as well, and then we can turn to scheduling the outstanding motions that we have.
Of course.
Judge, we really do want to address the home venue privilege, which is why we're before you at this moment. What Mr. Coffey tried to address before the court at the last hearing was an emergency motion for a mediation, which was denied by the predecessor judge. The predecessor judge set a scheduling order whereby on Monday, both defendants were ordered to file their motions to dismiss. The plaintiffs were ordered to respond to those by Wednesday, and we were then ordered to reply to those by Thursday, and the predecessor judge indicated that he would conduct a hearing on the motions to dismiss on Friday. Since that time, as you know, Judge Arzola recused himself, Your Honors, pointed to the case. Mr. Coffey telephoned me to discuss scheduling and advised that he would file a response to our venue motion yesterday evening, which he did. He asked me whether or not we could hear the venue motion first. And we, on behalf of the state of Florida defendants, agree that that should be heard first.
Would you like to hear that tomorrow and then set the remainder on Friday?
Yes, Judge, we believe exactly. We will file a reply sometime today, and we're able to, I think both Mr. Coffey and the state defendants agree that we can hear the motion to dismiss based on improper venue tomorrow.
And then to schedule the remainder of the motions to dismiss for Friday, if necessary?
Yes.
Okay.
Yes, Your Honor.
Fine.
This is Kendall. We agree with that procedure. Certainly before other, momentous issues can be reached, we need to make sure we're in the right forum. We think we are, but
Okay.
I think venue comes first.
Mr. Cortinius, how long do you all, both sides, need tomorrow for the venue motion?
We believe an hour for both sides is more than enough, I imagine.
Okay.
But I can't speak for Kendall.
Do you all have a preferred time during the day?
Your Honor, I do, if it's possible to do it late morning. I say that because everything is urgent about this case, but that one we really want to address as quickly as possible. And I think an hour with both sides, including both sides, is plenty.
Yeah, and we have no problem with tomorrow morning, Judge.
Okay, so what time is that, 11 or 12 that you prefer? Which time do you all prefer, 11 o'clock or 12 o'clock?
11 is better.
Okay, so we'll set that one 11 o'clock on Thursday. Did you all discuss then the setting of the remaining motions to dismiss on Friday?
We did. The only thing, and I don't want to speak for Mr. Coffey, but he hasn't filed a response yet, so I don't know if he's in a position to file the response yet.
Well, I don't know either, but in that original briefing schedule, the response wasn't due until tomorrow, and the hearing was anticipated on those other motions for Friday. So
No, I think the response was due today, Judge.
Your Honor, speaking for the plaintiffs, if it's not an imposition on the court and other parties, we have two responses that are due on motions to dismiss, one from the mayor and one from the state. They raise, not surprisingly, some very different issues. We prefer to respond to that by noon tomorrow, but we can respond tonight if that's best for all concerned. And then we're available Friday at any time that meets the court and the other parties' convenience.
How many hours should we set aside for that hearing on Friday?
We think 2 hours, Judge, at least.
Okay. Maybe 3 hours?
Maybe 3.
Okay. What time is good for you, Mr. Cortinez, on that one?
Anytime Friday is fine, Judge.
Okay. Same time then, 11 a.m.? Does that work for you, Mr. Coffey?
Yes, Your Honor.
And there's also an outstanding motion for temporary injunction. We scheduled sometime after all of that. Is that something that you anticipate will take several days, Mr. Coffey? What was your plan and your attempting proof on that?
We think it would take a day, Judge. Many of the issues, I think, are actually not going to require extensive witness testimony. Many of them are predominated by legal issues.
In some of your papers, you mentioned the possibility of some school districts beginning classroom education on August 10th. I'm not quite sure that that's happening or that that's a reality. Does anybody have information as to when is the earliest time that that might occur?
Your Honor, I'll just speak about a couple of districts that I spoke to. There are some that are opening. The one I was speaking to specifically was August 11th, but I think there are some that are opening August 10th. Many of the districts have pushed back at least a few weeks, but it's perhaps the education department has a better sense of that.
Does anybody have an idea of that?
Your Honor, Mark Richard, there are some school districts where employees have already begun to report as we sit here without students, and there are multiple districts starting next week.
And Your Honor, like we pointed out to Judge Arzola, what they're asking you is to become the receiver for the entire school system in the state of Florida and all 67 school districts. And the fact of the matter is that for Miami-Dade County, there will be no classroom in classes in the month of August.
Your Honor, just if,
Are you requesting me to set now a hearing on that motion, or do you want to wait until we hear the motions to dismiss over the next few days?
Judge, this is Kendall. I think we should have some time set aside because with due respect to my distinguished colleague, we're actually not asking you to take over all the school districts. In fact, our position is that 67 school districts should make their own decisions, not pressured financially or otherwise by an illegal and unconstitutional state order. But if the relief were granted, then the school districts would be essentially free to do as they determine best based on their local needs. But I know we're not here today to argue the merits. So what
but we're here to schedule it. So when are you requesting a hearing?
We request a hearing beginning Tuesday. Well, let me. Can I just ask my co-counsel, Mr. Richard? He's more directly involved and knowledgeable of the day-to-day school realities.
Yes, Mark Richard again, Your Honor. Really, the soon as possible, because incredible amounts of decisions are being made.
As soon as possible would be Friday. If the case is not dismissed on Thursday or Friday, we could move into the hearing. The next soon as possible after that is Monday. So, you know.
I think Monday would work, Your Honor, so everyone can be prepared. But I just want to add one thing with the court's permission, and that is, along with the many serious health issues, as we sit here today in Dade, I've represented that teachers union for many years, and in many other counties, multiple, I can't say all 67, but I am certain that I can extrapolate to all 67. Many teachers, educators, staff are making irrevocable decisions to retire. They are making decisions through their FRS plan to take lesser benefits because regardless of whether a school is opening Tuesday or a month from Tuesday as scheduled, you have to make these decisions. They are recalculating their Fair Labor Standard, their Family Medical Leave Act banks and how much they can use and when they can use. And so schools are making decisions that even
So why are we doing this on Friday then?
Yeah, so these are very serious issues, and we would take, Kendall, it's up to you in terms of preparation, and Angel for Friday
defense,
and Monday.
We're prepared to begin at 9 o'clock with the motions to dismiss, Your Honor, and then proceed to the injunction motion.
Okay, does that work for the defense?
Your Honor, just to point this out to the court so we can be clear about this, the state of Florida defendants are entitled to an automatic stay should Your Honor deny our motion for an improper venue. We would then take that appeal to the 3rd District Court of Appeal.
Well, then we're not going forward on Friday anyway.
Correct.
On either motion.
Correct.
So we don't need to schedule them if that's the case. I don't know if you all discussed that, because if that's the case, if I grant the transfer of venue, then we're not going forward here on Friday. And if I deny it, then you're going to take an automatic stay and we're not going forward anyway. So I guess we don't have to schedule anything.
That's right, Judge.
Is that correct, Mr. Coffey? Do you agree with that statement?
Your Honor, I wasn't aware that the state had already made a decision about invoking the automatic stay, but I accept Mr. Cortinez's representations of their intention.
Well, in that case, all we have to do is schedule one hearing.
Your Honor, if I may, Mark Richard, one more time. We didn't know that. I accept my colleague's representation, as disappointing as it is. But we would be also contemplating, I suspect, going to the appellate court as well to see if that stay could be lifted. These are life and death, no do-over decisions. We would think the courts and the governor and the secretary, the commissioner of education rather, would like our day in court so these teachers and parents can get at least the direction of where we're heading. So
let's reserve those times, but with the understanding that this that will be dependent on if the motion to transfer venue is denied, that will depend on a stay being lifted.
That's accurate, Your Honor. Legally, that's accurate.
So let's reserve those times, which would be 9 a.m. for the Friday for the motion to dismiss, and then 11 a.m. or whatever time we can begin on a motion for injunction, temporary injunction.
Your Honor, may I complicate things briefly?
Please. Who's speaking, please?
This is Dave Murray on behalf of Miami-Dade County, sir.
Sir, please.
Your Honor, if this court rules on the venue motion, that would potentially then divest this court of jurisdiction to hear the mayor's motion to dismiss. Would it be possible to have the mayor's motion to dismiss only heard either before or at the same time as the motion for venue filed by the state defendants?
Tomorrow.
Yes.
I don't think the plaintiffs have responded to that motion yet.
Your Honor, we would object to that. We think that the mayor is an appropriate party, but certainly there are other parties that represent the center of gravity in this case.
What relief are you seeking against the county?
Your Honor, we are seeking a declaratory action based upon the emergency order, and part of the declaration would include acknowledgement that the order as framed by the state education commissioner necessarily requires or envelops directives or input from the county mayor. And we say that because with respect to this particular order, and this is the language that I think is relative, it speaks to being subject to local health directive. Subject to local health directive. The structure of Miami-Dade County does not create an independent local health care department. the voice of local county government on the COVID matters has been consistently and exclusively the mayors, specifically the county mayors. So the proclamations, the health concerns, the health directives have consistently been issued by the mayor. So to the extent that the emergency order by its terms envelops the directive or the input from the mayor, if there is an unconstitutional lack of safety in the public schools, we think the mayor's voice needs to be part of that. And there is a specific provision that the mayor has cited, Section 8B7, in his proclamations and shutdowns and stay-at-home orders. And that provision authorizes an order closing the public to any or all public places, including streets, alleys, public ways, schools. So he is the necessary local component of any action to open public schools. We believe he can veto it and should, if that were to come to that. And we believe in all events, it's something the mayor has to weigh in on. Because this action was predicated on venue in Miami-Dade County, Carlos Jimenez, the office of the mayor, was the named party. We certainly believe that this applies equally to the other 66 chief executives of counties throughout the state of Florida. So our legal position is that there needs to be a declaration that he has the very role that we think he has consistently assumed throughout the COVID crisis. And secondly, that is provided in the emergency order, there is a direct duty for him to provide input before any opening of schools can be done, even under the terms of the emergency order.
What relief are you seeking against the county? That's different than the relief. The declaratory relief will be the same. Is there any special relief that you're seeking against the county that would be unique?
We wanted that unique as opposed to the other 66 counties? No,
as opposed to the other defendants.
That relief, Your Honor, is to declare that he is indeed the responsible for the health care determinations with respect to the COVID, that he is the source of data, the source of decision-making, just as he has assumed throughout this crisis. From that declaration, the additional component would follow that we believe that he has a duty based on the available data to weigh in against the opening of schools, and he's named as part of the injunction claim. So it's declarations and then a delineation of what his duties are, which is perfectly appropriate for declaratory relief, as well as injunctive relief.
Mr. Murray, I think we're going to have to leave your motion to dismiss to be heard on Friday with the others, particularly because the other parties have not briefed it and it was not anticipated in Judge Arzola's scheduling order.
Fair enough, Your Honor.
Anything else that we can accomplish today?
Your Honor, just in light of Your Honor's scheduling, could we have their response to the motions to dismiss come in by tomorrow, close of business, even if it's late evening, so that we may properly reply before the hearing on Friday if it were to take place?
I think so. Isn't that when it's due?
Yes, Your Honor. We'll provide them tomorrow by close of business.
Great.
And we will file a reply, Your Honor, in support of our motion to dismiss for improper venue later today.
Thank you. Anything else from any party? Okay. Well, then thank you all, and we'll be in recess for today, and we resume on Thursday. That's tomorrow, 11 a.m. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.